Certain that the defects were there regarding any some document.
20.
20, yes.
RP Sharma, London Senior Counsel, assisted by
Then-
Sri
Mbora.
M. Bora, Learned Counsel for the petitioners, submits that as per instructions, the writ petition may be permitted to be withdrawn. Para also heard Sri SMT Chisti, who does not object to the said prayer. Para writ petition accordingly stands dismissed on withdrawal.
With liberty, my lord.
ऊपर में लिखना permits to withdraw with liberty. हाँ और नीचे भी लिखना with liberty as prayed for.
Yes.
Yes.
My lord, one more prayer is there, my lord. In item 22, my lord, exactly some, in fact, only one addition has been made, my lord, regarding press advertisement, when the matter is pending here. So, my lord, along with the item 22, I may be allowed to move this new petition, my lord,
Today,
today.
have you filed?
Yes, my lord, already filed somebody. Yes, I may be given.
Will it be possible?
Yes, my lord, item 22, lordship is taking, along with that.
Okay. Just try.
Yes, two, my lord.
In item number
Yes,
20,
Mr. Chisti.
this is higher adopted. That's
Hmm?
item 20. Higher.
No, he wants to move on unlisted,
What?
which is connected.
Along with 20. Yeah, 8-2, my lord.
Please inform them.
Yes, I-
Please inform that you're moving it today.
Possible.
Yes,
Item number 22, Lordship.
22.
We have filed, Lordship, one
Yes,
affidavit in opposition on Saturday, Lordship. That may be called for.
You're for whom?
I'm for the respondent number 4, Lordship. which
Okay,
is
you
governing
get
committee.
the affidavit.
Yes, sir. Highly apply.
May I please, Your Worship?
Yes,
Your Worship, declaration item number 6, Your Worship.
6 years.
Your Worship, on behalf of Mr. K. Mira, he is unable to appear today due to some personal difficulties. So, matter may be passed over. to
Okay. Elementary. On a request made on behalf of Sri K. Mira, Learned Counsel for the petition, matter is adjourned by a week.
Yes, sir.
Yes. Item 6. Yes.
My lord.
May it please the Lordship, I beg to mention item number 17, my lord.
17.
Yeah.
Yes.
The English council is out of station, my lord. Let the matter be passed for the.
Okay. On a request made on behalf of the petitioner, matter is adjourned by a week.
Can the matter be fixed for Friday, my lord?
1 week. Yes.
What?
Next.
May it please, Your Lordship, I beg to mention for listing of writ petition, Your Lordship. It was lastly posted on 7/6/2024, Your Lordship. It's already 1 year, Your Lordship.
7, what is the matter?
It's regarding promotion of the petitioner, Your Lordship.
Okay, 7, 6. Okay.
On-
Friday next.
Your Lordship, if possible on 5th, Thursday.
Thursday, no, not new. Friday.
Highly obliged.
If I may, Lordship. Lordship, with consent of the petitioners, Lordship, I would like to mention item number 21.
Yes.
Lordship, I'm here on behalf of Mr. A. Somo for the UTC. Lordship, we are yet to receive instructions from the
I've
department.
taken the instructions.
Yes, Lordship.
Okay. On a request made on behalf of the
Hi.
UGC, respondent UGC, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Is there any interim order?
No, my lord.
Okay.
My lord, item number 8, my lord. Mother of Mr. Arthur is under surgery, my lord, and BP is with him, my lord. So
Okay.
matter may be passed over for 2 weeks, my lord.
Okay. But why did you mention this matter to be listed? Why is it come by orders?
No.
Why has it come by orders?
Sir,
Who had mentioned the matter?
No, he does not know the mother. His mother is my lord.
Mother is
under
Oh,
surgery, my lord.
Okay, okay. A prayer for adjournment has been made on behalf of Sri Ardhar on medical emergency. On medical grounds. Para, in view of the above, list after 10 days
Obliged.
for
Okay.
motion.
May I please, Your Lordship? I beg to mention item number 18 from regular hearing list, Your Lordship. Lordship, my senior, Mr. Hasibul Rahman, have some problems, so kindly listen.
Item number 18 of what list?
A regular hearing list.
What is regular hearing list?
Part two.
Part 2.
Part 2, there is no separate list. If it comes in the part 1, we'll take up. No need of mentioning. Has it been listed in today's list?
No.
Then no need of mentioning.
Wait,
Yes.
please, Lord. Lord, item number 28 to 37.
But in this, my lord, I pray for 3 weeks time for filing affidavit. The
These
counsel
are,
for the petitioner
these are connected matters.
connected.
Yes, Lordship.
Mr. Purcaster?
Yes, Lordship. All are connected, same matter.
Issue is same.
Okay. You're for the department.
Department.
On the prayer of Sri B. Kaushik, Learned Training Council, Secondary Education Department. Matters are adjourned by 3 weeks to enable him to file the affidavit in opposition.
Great.
Interim order may continue, my lord.
Sri B. Purcaster, Learned Counsel for the petitioner, para karke, huh? However, informs that there is an interim order which is required to be extended. Para. Interim order accordingly stands extended till the next date of listing.
Great.
Okay.
Lord.
May I
Yes.
please, Your Lordship? Lordship, I beg to mention for listing of 2 matters, Lordship, one contempt and one writ petition. Lordship.
For what?
One for admission, Lordship, and another for orders.
Contempt of which year?
2024, Lordship. It was last listed on 5/12/2024.
Okay, contempt Friday. Then writ petition, which year?
2024, Lordship, regarding pension.
Pension, okay, Friday.
First, Lord.
May I please, Your Lordship, praying for listing of a fresh matter.
Press matters whenever, would one day after tomorrow.
Right.
Have you filed or not, madam?
I beg to mention item 44, my lord. In this case, my lord, some progress is going on. Orders have been issued, but the salaries are yet to be received. So 1 week time may be granted, my lord. By this time, I think the orders will be
Okay.
complied.
Sri B. Purcaster, Learned Counsel for the petitioner, has submitted that instructions have been received, that there are certain steps taken towards compliance of the order in
Yes,
question.
yes.
Full stop.
We have already sent a proposal to the pension department.
Para. Then we can close this.
No, the salary has not
That
been,
I have, that is here actually, I have said that this could have been.
orders have been issued, my lord, salaries have been
Salaries
dispatched.
will be there. Where is the
Let it
compliance?
come
Where
after-
is?
After 1 week, my lord.
Para. Sri SMT Chisti, Learned Counsel for the respond numbers 2 and 4 has however submitted that the order in question has been complied with and the necessary orders for pension has already been issued by the department. Para. Be that as it may. List. The matter is adjourned to be listed after 1 week. Yes.
My lord, I beg to mention item number 48. My lord, similar, my lord, some development has been taken place.
Item for
48, lord.
Here also we have issued a complaint, sir, but he requests some time. Lord.
Sometime, my lord, complaint I expect next week, lordship.
same, same. D Gogoi. Then you appear for whom?
And for the respondent, lordship,
SMT 60, respond number
one.
1, huh?
Yes.
1 or last me like the name of Sri Chisti, SMT 60 be reflected in the
Just
cause.
respondent. Correct.
The name of SMT 60 be reflected in the cause list. 1 week.
I'll hold it.
Yes.
Item 1. This is contempt petition. The order passed by this honorable court on 2nd of May, not complied by the respondent authority.
Which order dated what?
My lord, order related to,
Order dated, what is the date of the order?
my lord, 2nd May,
Of?
2025. This day. And the order, it was directed that the representation of directed to be disposed of on 6th of May 2025. My lord, it is in page number 18.
On or before 6th of May.
My lord.
Otherwise, we would have asked the question why you have come so early. Okay, there is a date. Okay. Heard, what is your name?
M. Hendrik.
Heard Sri M. Hendrik, learned counsel for the petitioners who have complained of willful and deliberate disobedience of the order dated so and so, past in so and so. Full stop. The learned counsel has submitted that the representation was directed to be disposed of on or before 6/5/2025, which has not been done. He has also drawn the attention of this court to the representation dated 2/5/2025, forwarding the copy of the order of this court, para, issue notice, returnable by 4 weeks. Let steps, 6 weeks, let steps be taken for service of notice upon the sole respondent by registered post with AD, steps within 2 days. Yes,
Please.
next.
May I please repeat? My lord, this is contempt matter, my lord. Today first time has come, my lord.
What is the order?
Order, my lord, at page 51, annexure 13.
Hmm?
And the relevant portion, my lord, page 60, paragraph 14. my lord. He is a teacher of higher secondary school, my lord. His service was not
No,
provincial.
no, we are not on that. What is the direction?
Direction page 60, my lord, paragraph 14. It was directed to consider and complete the process within 3 months. And accordingly, it was submitted, my lord, page 61 application.
Why do you make the contempt petition so bulky? What is the necessity of these
Yes, my lord.
annexures?
Yes.
Why?
Only for the department, my lord, they may see all this,
Why?
my lord. to
You're only
consider.
supposed to give the order of the court your representation. Why all these annexures of the court, writ petition? We are not adjudicating a writ petition. We are only examining whether the direction of this court has been complied or not. Don't
Yes.
make this bulky
Next time, my
unnecessary.
lord, I will.
It will not be of any use for you, any use for the court. Other will spend, there will be wastage of space, wastage of time.
Yes.
Heard 3 a.m. Borbhuya learned counsel for the petitioner who has complained same, huh? Order dated 22/3/2024. 22/3. What was the time?
3 months, my lord. From the date of submission of the
22/3/2024 past in so and so, huh? He has also drawn the attention of this court to the representation submitted requesting for compliance of the order. Para, let notice be same, baki sab same, no? 6 weeks. एक ही respondent. Registered post ready. 2 days. Okay.
oblige.
Yes.
My lord, relevant order page 24, my lord. Paragraph 12. Compliance order pursuant to this direction, court has interfered, my lord, that we all impugned orders.
Thereafter, what has happened?
Thereafter, my lord, compliance order has not been issued.
Hmm?
Follow-up order that has to issued, my lord, that has not been issued.
What is page 25? What is page 25?
Page 25 is, yes, because this order is not issued, my lord, we have to, our candidature for regular promotion has been rejected, my lord. And therefore, we have to put another proceedings, my lord, for challenging that order. Yeah, the court has
Why
granted,
are you so late?
not late, my lord, order was passed on 11th of April, my lord, and
No,
thereafter,
24/4/2020, 11th of April.
yes. This was the second round of litigation. Earlier round of litigation, they have passed the compliance order, my lord, that is set aside by this honorable court in the second round of litigation.
11/4. Today is what?
First case was at page number 15, my lord. In the first case.
No, you are alleging non-compliance of which order?
Page number 24 is the order dated.
Then you have already approached this court on writ jurisdiction.
No,
in
that
the
is,
second writ
that is
petition.
for, my lord, separate, only for headmaster promotion, and it is for in charge principal.
Heartily be broadcast a learned counsel for the petitioner who has complained about non-compliance of the order dated 11/4/2025 passed in WPC
2136 to the
2136 of 2024. Full stop. He has also or the representation है ना? Same. Submitted its file representation, huh? Dated 25/4/2025. Issue notice 6 बाकी सबसे 6 take steps by tomorrow. Restart post AD. Respondents, huh? There are 3 respondents.
May I please, Lord? On the last day, instruction was sought for as to whether any appeal by filed by another teacher or not. Well, in fact, Lordship, the service of the petitioner has already been provincialized. My provincialization order was put under challenge. In the interim, there was a direction not to release his provincial benefit. In the subsequently, Lordship, the writ petition is disposed of, directing the petitioner in that case
Yes,
to
Mr.
prepare an appeal.
Yeah, waiting instruction.
Well, I am not even getting current salary. In fact, there is no bar under law, Lordship. The order is only directing to file an appeal. That is, your Lordship will find the final order, page 30.
Okay, we'll issue notice.
Well, current salary may be released. That can be.
Heard Sri M. Khan, learned counsel for the petitioner. Full stop. It is the case of the petitioner that his services were provincialized as assistant teacher within bracket tutor via an order dated 5/2/2021, which however was the subject matter of challenge in WPC 1277 of 2021 by another teacher of the school. Full stop. Though there was an interim order in the said writ petition not to give the benefit of such provincialization, the same was the writ petition का number दिया क्या? 1277 दिया ना? But the said writ petition was disposed of via an order dated 21/2/2024, directing the petitioner in that case to prefer an appeal under Section 14 of the So-and-so Act of 2017. Full stop. It is the case of the petitioner that no appeal has been preferred in terms of the aforesaid direction, and yet the salaries of the petitioner have not been released. Let notice be issued, returnable by 6 weeks. 3. B. Kaushik, learned standing counsel, Education Department accepts notice on behalf of
1, 3, 4, and 5.
1, 3, 4, and 5. Whereas P. E. Chaliha, Learned Standing Council Finance Department accepts notice on behalf of respondent numbers 2 and 6. Let extra copies be served upon the Learned Council for the respondents. Para. 3. Khan, the Learned Council, prays for an interim order. Full stop. Para. As apparently there is no bar in the aspect of release of the salaries to the petitioner, comma, such salaries are to be released provided the petitioner has been rendering his services. Are you in service or not?
Hello?
Are you serving or not?
Yes, Lordship, serving, I am serving.
May it please your lordship, my lord, in this case, my lord, my pair before your lordship to open the Darpan portal, my lord. Since the 2005 school is running, my lord, but this time they have inactive the Darpan portal, my lord.
What is
Earlier-
what is this portal? What is this portal?
Darpan portal, my lord.
What is it about?
The open
There
portal
is-
means, well, it is maintained by the council. It is the admission. So prior permission is necessary from the TS. If TST give the prior permission, then we will open it for registration.
You are
Without-
for the council.
Yes, as per rule.
And DSC?
TST,
My lord, what happened in this case, the school is running last year also. This time they have inactive the Darpan portal and students are be able to get admission, my lord. They are
Yes,
staying
madam, you
during
are for the
here.
department. What is your instruction? Council says that if the decision,
Third time I said.
we have received instruction.
My peer is to open the Darpan portal, my lord, and science section is
okay,
already running, my lord.
madam, we issue a short notice. We give a date and madam,
Yes.
you take instructions. Okay?
Yes, my lord.
Oh,
Because science section is going on, my lord.
Okay.
The art is
third, Ms.
inactive, my
K.
lord.
Devi, Learned Counsel for the petitioners
Right.
who have approached this court with a grievance that the concerned Darpan, DRP and portal has been closed so far as the school of the petitioner is concerned, namely the Lakhijan
Yes, my lord.
HS school
Lucky HS.
in the district of Dhubri. Full stop. Para. When this matter was listed on 16/5/2025, Sri T.C. Chutia, Learned Standing Council, ASSEB, was directed to obtain instructions. Full stop. Sri Chutia, the Learned Standing Council, has submitted that he has obtained written instructions on 22/5/2025, as per which the decision is of the Director of Secondary Education. Full stop. Para. Let notice be issued. Returnable on. We give a returnable date. Today is 2nd.
Second, my lord.
We'll have it
Friday,
on
my lord, Friday.
Friday, not possible. We'll have it on 11th.
11.
11th. Next Wednesday.
Yes.
11th. Sri Chutia, the
11th.
Learned Standing Council accepts notice on behalf of.
As per number 4,
No, madam, your name? Miss N.M. Sharma, Learned Standing Council. Secondary Education accepts
1 and 2.
notice on behalf of respondent numbers 1 and 2. 1 to 3 also.
3 also.
3.
Inspectors.
Whereas Sri T.C. Chutia, Learned
Four-
Standing
four-
Council, ASSEB accepts notice on behalf of respondent numbers 4 and 5.
4 and 5.
Let extra copies be served upon the Learned Council for the respondents during the course of the day.
Yes, my lord.
Para. By the next date, Ms. Sharma, the Learned Standing Council, would obtain instructions regarding the grounds, regarding the decision taken in this issue.
Highly obliged.
Madam, are you equipped with this letter?
thanks, sir.
Please give her a copy. Yes, Mr. Boni. What
May
is this
please, Your Lordship.
affidavit?
My lordship,
What is this affidavit?
well, we had got on record an FIR submitted, filed by us, and the reply to the show cause which was not there earlier, but that's not relevant for the present matter.
There is a caveat.
No, he was appeared. If it was it, discharge.
Caveat
Not
is discharge.
Discharge, I
No,
believe
no,
discharge.
no.
Anyways,
Okay.
he's here.
Okay, heard 3 SB last
Discharge one again.
Learned Counsel for the caveator which has been lodged in connection with an order 17/5/2025 passed by the Director of Elementary Education, Assam. Para, the caveator would be heard in the event this court proposes to pass an interim order. Para, caveat stands discharged. Yes, Mr. Bonik, what is this?
My lordship, may it please, Your Lordship. Well, I was continuing as the in-charge headmaster of Chandranathpur ME School.
You are in charge as master of a school.
Of a school. Now, my lord, on many other issues, including, I must be fair, on an issue of alleged inflictment of corporal punishment on a student, I was show caused. That's on 30th of November.
Show cause by the
2024.
department.
That is by the Block Elementary Education Officer category.
Hmm. Yes.
That was under the Assam Services Disciplinary Appeal Rules 1964.
Hmm.
I've made a statement
Yes.
that the show cause notice does not reflect articles of charge, statements of allegation, list of witness, or list of documents. Expressai, that is.
Yes.
Nevertheless, we have submitted a reply. But on the aspect of the corporal punishment, the matter was heard by the Jurisdictional Commission, and possibly there was some recommendation from it. I was also a part of the hearing. Eventually, the order came at page 17.
17.
Before I read the entire part, I just like to point out, the punishment which has been given by the order at page 17, 17th of May 2025, is under exercise of jurisdiction of Rule 7.2 of the Assam Services Disciplinary Appeal Rules 1964.
What is this order?
That order is it says, I'll be transferred and one increment, annual increment to be stopped without cumulative effect.
Yes.
The tall and short of my submission would be, Milord, that regardless of anything, on the recommendation of the commission, an authority exercising jurisdiction under the disciplinary appeal rules could not have inflicted any punishment on me. Certainly, if you feel so, you punish me, kindly follow the rules. May I read the order? I'll come to the aspect. Where is the, may I read me?
Where is the show cause notice?
Show cause notice 14. Amongst others, that ground is there. May I?
Just a minute. Who is your disciplinary authority?
Disciplinary authority is the inspector.
Director of
Director.
Director. Then how was this show cause notice issued by the BEO?
Regardless of that, we submitted a reply.
No.
I understand. I understand.
Now, under what?
If there will be some delegation of power to
Delegation of power
I do not know.
by disciplinary authority.
I do not know.
How was it issued?
We are only on that, whatever show cause is there, it has nothing, it does not reveal the basic requirements of the rules of 64.
Now, who issues a show cause notice? Yes, Mr. Pegu. Are you representing the department?
Yes.
So far as a headmaster of a school is concerned, who is the disciplinary authority?
ROPD.
Director. Then how come a BO can issue a show cause notice? Under what authority?
Director has also taken a hearing, my lord.
one judgment,
No, show cause notice.
my lordship,
Who has initiated the proceeding?
my lordship.
Are you the BEO?
No, my lordship.
Then what authority? Sit down. We'll hear you. Who are you?
I have the caveat, my.
Caveator, who is the
I have
caveator?
approached the Honorable High Court, my lordship.
Who are you?
Petition. I am the mother of the child who was the.
Okay, you are the victim. Just have you a seat. You'll get a chance. We are on a pure point of law. We are not on morality. Have you initiated a criminal case?
My lordship. I have my.
No, have you initiated a criminal case? You're not answering, Mr. Laskar. Have you initiated a
No.
criminal case? Just say yes or no.
Right.
Why do you say I filed representation? Yes. What is the basis of your initiation? It's faulty. You may have good grounds.
Yes.
Go in accordance with law. And can you have a disciplinary proceeding without an article of charge, without statement of allegation, without list of witness, without list of documents? 1964 goes for a toss.
Correct.
Hmm? No, you advise them properly. These are serious matters. He may have a very serious case. Why do you deprive his this victim? Mother has come. That is within your domain. But once the matter comes before us, we have to go by law. Now, what is the stage, Mr. Bonik?
Stage is that 1st of January 2026, I'll retire. As of now, no one has moved. And we have.
You have retired already?
No. 1st of January, coming year,
Okay.
26th, will retire.
Okay.
So my submission was, Milord, like the Sexual Harassment Act, the inquiry report becomes an inquiry report after the mental illness in that case, Milord, on the DP. But so far as the Child Right Protection Act, they do not have the jurisdiction. They only recommend for initiation, either to the magistrate or to the authorities. Now they are acting on the report of the Child Rights Commission, apparently, Milord, without following under this and punishing me under different rules. That wholesome, maybe. I also feel for the mother as an officer of the court. But perhaps on the face of it, if you take recourse to the law, to follow it. They jumped over the law.
Where is the final order?
Page 70. May I read that?
After acceptance of the findings in the manner as made by the inquiry committee. Which is this inquiry committee?
This is under the Commissions of Protection for Child Rights Act 2005.
Where is that report?
That report we do not have. They may have a report, but they've acted on the report.
Was it served upon him?
No, I'm not on having or not having. No, what I'm saying is that we appeared in the hearing. I'm not assailing the report. For a moment, I'm not assailing the report.
No, Mr. Bonik, tell us one thing. This 17/5/2025, is it an outcome of 30/11/2024 or is it a separate proceeding?
17/5/2025 is a culmination of two things. Number one, a show cause notice issued under the rules of 1964.
But this 17/5 does not even mention anything about 30/11.
If Lordship comes down to the bottom, Milord.
Yes.
May I read that part? After acceptance of the findings in the manner as made by the inquiry committee.
No,
under the rules.
That is the penalty part.
The penalty made part under the rules.
No, that is the penalty part. What is
the last part? The last
penalty.
Correct.
What is the process adopted?
Process, they do not follow the rule 9, although they punish me under rule under 64 rules. That's my Mary.
That we have read.
That just the part, Milord. With immediate effect by stopping one so and so and so. under provision
Let
two-
us see this, this
Ma'am.
thing. Is there a reference that the concerned rules will be applicable,
No.
just like the,
Unlike the POSH Act,
yes,
POSH Act, it becomes an inquiry report, but here the judgment would be made a Kotwal Lele Miller. I don't get that. But so far as this, it only has the recommendary part. It would recommend either to the magistrate or to the authorities. We have these things. It does not become an inquiry report per se like that. That's the distinction.
yes, what do you say, Mr. Laskar?
That's the point of law.
The highlight petition, my lord, he also appeared. I also.
No,
appeared.
but no, that is okay.
And six
but-
recommendation.
But the punishment is prima facie under the 1964 rules.
Yes, ma'am.
It has been
That is,
stated.
that is admitted.
Now, if it is under the 1964 rules, the procedure laid down in 64 have to be adopted.
Yes, ma'am. That is the.
That has
I
been
can- I
adopted.
can-
That has not
but
been followed.
My.
No, second question, just don't hurry up. Like the POSH Act, the prevention of sexual, this thing in the workplace, that has got an inbuilt mechanism. How do you proceed?
Yeah.
Now here, and that also, and we say that the concerned rules would be applicable so far as the penalty is concerned. In this particular
1450,
case,
no.
is
It's a
there, such,
recommended
is there any such provision? Have you examined that part?
My lord.
What is your take?
The Honorable High Court, my lord, a writ petition, which I have this order, my lord. Take one.
You have filed. You had filed.
Yes, my
Yes.
that hearing was taken. The Honorable High Court directed for taking a test. And my lordship, my transfer. He is working in the same school since 12/5/2005. Transfer is not a punishment. And this is the minute. And he also appeared in the hearing, my lord.
Thank you. To take a decision on delegation.
It didn't connect the mind. He appeared. Several recommendation has been made on the next page. Six recommendation has been made by.
In view of the consent of the parties, they will take a decision on the allegation made against. Okay. Third, three,
And may I please on this 1415 of the
heard three as Bonic, learned counsel for the petitioner who has put to challenge an order dated 17/5/2025 issued by the Director, Elementary Education, Assam, whereby the petitioner has been awarded penalty, has been transferred and posted at the Burunga MES with along with stoppage of one annual increment without cumulative effect under the Assam Services within bracket Discipline and Appeal bracket close rules 1964. It is the case of the petitioner that on an allegation of inflicting corporal punishment upon a student by the petitioner, who is the in charge headmaster of the Chandranathpur ME school, a show cause notice was issued to him on 30/11/2024 by the Block Elementary Education Officer. Full stop. It is the case of the petitioner that the said so cause though had stated to have been issued under Rule 9 of the aforesaid rules did not contain any statement of allegation or definite charges, apart from there being no list of documents or list of witness. Full stop. Nonetheless, the petitioner had responded to the same, whereafter the impugned order has been passed. Full stop, para. Three. S.B. Laskar, the learned counsel, appearing for the respond number.
I have not made respondent, I have.
Learned counsel who has filed a caveat on behalf of the mother of the child has submitted that his client has not been made a party in this proceeding, and even though if she is a necessary party, full stop, he has submitted that his client had earlier approached this court by filing WPC 854 of 2025, which was disposed of by directing the authorities to take a decision and communicate the same to the parties, and pursuant to the same, a meeting was held on 1/1/2024, in which the present petitioner had appeared. The said meeting, however, appears to be conducted by the Assam State Commission for Protection of Child Rights, Guwahati. Full stop, para. Let notice be issued, returnable by 6 weeks. 3. G. Pegu Learned Standing Council. Secondary Education, Elementary Education Department accepts notice on behalf of respond numbers 1, 2, 3, and 4. Who is 5?
Notice to go.
Steps, extra copies. Huh? Steps to be taken for service of notice upon the respond number 5 by registered post with AD. Para 3. Bonik prays for an interim order. How far is the new school?
It's around 40 something, 40 kilometers roughly. We have taken now there.
Transfer may not be constituted as a penalty. You go to the new school, but will stay
It's not on that count. We just said what I'm committing.
No, understood.
And
But
that only on that.
no, we have understood. Your point on the legal side, we have understood. But we are also thinking about the overall.
I understand. It we have taken in paragraph 9. We stated that petitioner is physically challenged person cannot work properly. It's pertinent to mention that transport pool located at a mountain climbing over 80 numbers of stairways, to reach about 26 kilometers away from the present school. So this is it's on the top difficulties there.
No, you think about the situation.
I understand.
The allegation may be
I understand.
completely false. It may be correct, but how do you resolve the situation?
For the time being, let there be eclipse. Let there be an in around. If there are better schools to be, it can work out, but certainly not on this way. Otherwise, some semblance of law has to be followed by.
No, semblance of law, we are, so far as the penalty part is concerned, if it's, see, this transfer has come as a way of penalty, otherwise they would have had better course of action. They have not taken. You cannot transfer as a measure. It's not prescribed by law. 64 rules does not contemplate transfer as a penalty. But
For the
you
time being, let's take over the matter.
you move to the other school.
Otherwise, not, I'm retiring on 1st of January.
Please for interim order. By submitting that the impugned order is wholly in contrary to the rules holding the field. Para. Considering the above, and after considering the facts and circumstances, this court is of the prima facie view that the impugned order dated 17/5/2025 does not appear to have been passed by following the prescription of law, both prescription as laid down in the 1964 rules. Full stop. At the same time, this court cannot be oblivious of the practical aspects which involves the allegation of inflicting corporal punishment on the son, on a student, full stop. Well, therefore, balancing the equities, while there would be a stay on the aspect of inflicting the penalty of stoppage of an annual increment, comma, there will be no suspension so far as the aspect of transfer is concerned, full stop. How since the petitioner has expressed certain difficulties in moving to the new school, the authorities may also explore if any other vacancies in nearby schools are available. List on, we give a date.
Not vacancy, my lord. It can be a shuffle.
If the petitioner can be posted in any other nearby school. Okay. Since the mother of the alleged victim has already appeared, Sri Bonik, the learned counsel for the petitioner, shall file an amended cause title incorporating her name as respondent number 6 or 7, who is already represented by Sri Laskar.
Highly object.
6 बोला था. Item 9.
May please, Lordship.
Yes.
But this petition is challenging the impugned release order, Lordship. This is at page, Lordship, 18.
Release order means?
Release order, Lordship, from the service, Lordship, from my contractual service, Lordship. Release order, Lordship. The agreement of so and so, draftsman civil law, component of Samagra Shiksha Abhijan, State Mission Office Samagra Shiksha
Expired
Abhijan.
on 31/7.
Lordship, Lordship, fact is different, Lordship. I was initially appointed in the year 2011, Lordship. Thereafter, no agreement, Lordship, no extension order was issued by the authority, Lordship. However, time to time, scale was granted to me, Lordship. And the post against which, Lordship, I was appointed, Lordship, still exists, Lordship.
Now, have they filled up the post with anybody else?
Lordship. No,
Have they
Lordship,
filled
no.
up?
Not, Lordship.
Are they contemplating to fill up?
Lordship.
Then if it is their discretion whether they want to continue or not,
Lordship.
you have entered as a matter of contract. How do you establish your right?
Since 2011, Lordship.
11 by way of contract.
But no agreement thereafter, no extension order, Lordship.
That is something grace, that by grace you are continuing for the last 14 years.
Lordship, I have not.
Now, how can you take support of that? You had got benefit out of that. Will it give you any right? Will it vest you any right?
Lordship, at least, Lordship, still the post is regularly appointed, Lordship.
That cannot be done. It is their discretion. Yes, why do you want to release him? You don't want,
Fact, my lord, if lordship posts that particular impugn order, there is a date 13/7/2024.
yes,
Date is fixed. This is the date of expiry.
31/7.
31/7. Definitely there is an agreement. Otherwise, this date will not come. That petition there is they have here not annexed that agreement. Because annually the agreement is done. And that since date is there is some agreement is
And this was on 2/4.
31/7/2024.
No, the
That agreement
discontinuation is from 2/4, Mr. Talukdar.
2/4, Lord.
You have come on 2/5.
Lord, my
2/6, not 2/5, 2/6.
At least this notice may be issued. One similar case has another difficulty, my lord. SSA is not made a part. Only the managing director is made.
Mr. Talukdar, you are not supposed to be. You are supposed to.
One
know.
similarly situated persons.
Why don't you make SSA a party? What is this?
Only the
SSA, you
managing
make
director is made.
SSA represented by the managing director. You should make the entity a party. Why this kind of? You are experienced counsel. Why do you make this kind of mistakes?
Now, let's
Part 3, Talukdar. H. Talukdar, learned counsel for the petitioner who is aggrieved by an order dated 1/4/2025 by which the petitioner has been released from her services as a draftsman, civil work component of the State Mission Office, Samagra Siksha Ahom. Full stop. He has submitted that such services are being rendered by the petitioner since the year 2011. Full stop. Though the induction was by means of a contract without there being any formal extension, the petitioner was allowed to serve, and suddenly the impugned order has been passed. Para. Let notice be issued, returnable by 6 weeks. 3 as Bora learned.
Only
Only
2 by education department is made.
one education.
Education department without
3
any
SMT 60. Learned standing council. Education department accepts notice on behalf of respondent number. State is not represented by Secretary Education. This is badly drafted.
Yes, sir. The draftsman and education department. I will impeach, Lord. I will impeach.
I have copy at our name.
No, this is not wrong. How do you make the state of Assam represented by Secretary Education Department? You can Chief Secretary can represent. Okay,
I will
Assembly
impeach.
60,
I have
Learned Standing Council. Education Department accepts notice on behalf of respondent number 1, whereas 3 S. Bora. Learned Standing Council SSE accepts notice on behalf of respondent number 2. Full stop. Both the learned counsel for the respondents have, however, raised the issue of non-gender of necessary parties. Para. Be that as it, let extra copies, huh? By tomorrow.
Obliged, sir.
Both the learned counsel there, last of the huh? Notice accept, extra copies, both the learned counsel as well. Take us. Okay, next. Item.
Here, my lord, the petitioners are working as my lord science teachers, and one is working since 2003, my lord, other from 2006 and 10. So, my lord, and the schools are provincialized. Their services provincial considered by the TLC, my lord, and recommendation are back in 2017. Again, there is no action at all. And ultimately, 2020.
Your names were perhaps not there in the list.
Hello?
You may be excess teachers.
No, not access. Without science manner, it will be provisional manner. They are continuing teaching. There is no other permanent science teacher. That's why it is called vacant, because we are not provincialized. to respond vacant in the list. We are teaching continuously. At the time of provincialization, my lord, we had no B.Ed. We were
But
given.
provincialization, can you claim as a matter of right if you do not meet the requirements,
No.
the eligibility
Then,
criteria?
my lord, by virtue of the 19,
Mr. Chaudhary, what do you say? We issue notice at this stage.
we have acquired qualification.
Third, Sri R.P. Sharma, learned senior counsel for the petitioners, assisted by A. Deka for the petitioners. It is the case of the petitioners that they have been serving as science teachers in various schools for a long period of time. And though they were considered for provincialization by the DLC, District Level Scrutiny Committee, DLS, District Level Scrutiny Committee, Kokrajhar, and also recommended for such provincialization, no final decision has been taken. Para, let notice be issued. Returnable by 6 weeks. Elementary, Fukan, M. Fukan, S4, Miss S4 Learned Standing Council. Elementary Education Department accepts notice on behalf of respondent numbers 1 and 2. Whereas Sri B. Chaudhary.
Important.
And what about 5? 5 also.
Five of that.
Learned Standing Council BTC accepts notice on behalf of respondent numbers 3, 4, and 5. Let extra copies be served upon the Learned Council for the respondents by tomorrow.
Right.
Available.
Here this case question, the petitioner is agreed for non-provincialization her service as grade 4 employee lot. First service of the petitioner has already been recommended by the state level selection committee on 12/12/2022. That
Mr.
is
Kaushik, what is this?
Take it back.
page 19 is the
Regarding the status of the
Third, Sri M. Khan Learned Counsel for the petitioner, who is aggrieved by inaction on the part of the respondent authorities to provincialize her service as grade 4 employee in
grade 4
the Raniganj Multipurpose Girls Academy in the district of Dhubri. Full stop. It is the case of the petitioner that she had joined her service in the year 2009, and as per the Assam Education within bracket provincialization of services for non-teaching staff of venture educational institutions bracket close Act 2018, the petitioner is entitled for such regularization, as her name was also recommended. Full stop. Para. Let notice be issued. Returnable by 6 weeks. Sri B. Kaushik Learned Standing Council.
for 1,
Elementary
3, 4,
Education
and
Department accepts notice on behalf of 1, 3,
4 and 5.
4, and 5. 6 also perhaps. 6.
6 followed government. Deputy government.
Talia for Standing Council Finance 2, and Bokolial for Deuri for 6. State Council. B. Deuri.
Item number 12 is similar.
12.
Only school name is different.
Schools will be different.
And working since 2000?
Same.
2009. No,
No, 1992.
Here appointment is 1990.
1990.
No, in that case, she was working since 2009. This is 1992. 2009, 1992, Kuriba. And the respondents are the same.
Respondent
স্কুলৰ নামটো হ'ল চাৰালি ঝাৰ এমি মাদ্ৰাছা ইন দি গোৱালপাৰা ডিষ্ট্ৰিক্ট, আগতে ধুবুৰী আছিল। And here respondents same respondent এনেকে, and Kaushik, Chaliha, Deori.
both the case may take to the
Let us see.
same issue, Lordship.
Let us see.
Otherwise, Lordship, in item number 11, Lordship, my name may be reflected, Lordship. That has not been reflected. Suddenly, Lordship, I forgot it.
11 not name of 3M can be reflected in the cause list. 11 not only 12 not now. Yes.
Item 13.
Mr. Das,
This petitioner also is seeking personal fixation of pay because earlier she was denied her appointment at the relevant point of time. Ultimately, she has been appointed on 11/9/2010. This petitioner is seeking personal fixation of pay.
Heard 3 SK Das, learned counsel for the petitioner, who by means of this petition is seeking the benefits of notional pay with effect from 2/5/2017. First up, let notice be issued, returnable by 6 weeks. Miss N. Sharma, N.M. Sharma, learned Channing Council, Secondary Education Department accepts notice number 1 and 2, Chaliha 3, Finance, extra copies.
Also, one more thing, sir. I am still getting also salary in my substantive post of English, although I have been appointed as regular principal on 11 and my principal pay maybe in the meanwhile.
Or by the next date, instructions may be taken on the steps taken for payment of the salaries to the petitioner in her present post as principal. Let the next date be fixed on what if 6 weeks, 4 weeks, 6 weeks to 4 weeks. The second, 2, 3. We'll have it on 26th, 26/6. Yes, what is this?
Lordship, we have come against the impugned communication, Lordship, that is on page number 20, Lord, Annex 7.
What is the limitation?
The Lordship limitation is 3 years, but we have the photocopy of the original admit card, Lordship, which states that her date of birth is 30/12/1966. Also, the admit card of 1983, where she failed to pass HSLC, Lordship.
Now, when did you approach the approach them?
We approached, Lordship. Actually, we lost the admit card in 2023, Lordship. We approached after filing of an FIR. We approached, Lordship. Thereafter, we filed a representation.
What is your name?
Mr. P.K. Das.
Heard Sri P.K. Das, learned counsel for the petitioner who is aggrieved by the action of the SCBA. Are you still called SCBA?
My lord, now
No.
ASSP.
ASSP.
Whom have you made parties?
Yes.
By the action of the ASSEB, Assam State School Education Board, whereby the representation of the petitioner has been rejected for correction of her date of birth on the ground of limitation.
Yes.
Also, let notice be issued, returnable by 6 weeks. You for?
My lord, I am for 2 and 3, my lord.
3D Roy Leonard. Now 1 is okay. N.M. Sharma 1, standing counsel. D Roy for 2 and 3. Extra copies. Serve extra copies upon them.
Deeply obliged.
52 supplementary.
Petition is presently serving temporary post under the Polytechnic. he had applied against the advertisement dated 30/12/2024 for the post of lecturer non-technical in humanities commerce. The advertisement is at page number 37.
In the
There-
same college? Same college?
My lord, it is for different colleges
Okay.
across the state, my lord.
There?
Wherein the minimum qualification for level 10, my lord, is that a master's degree with first class or equivalent in a relevant subject.
When was
and-
the recruitment held?
My lord, I was allowed to sit for the written test. I qualified that. Thereafter, the teacher's proficiency test was scheduled, my lord, and that was on scheduled, my lord.
No,
on-
your disqualification was communicated on which date?
It was not communicated, but when I sat for the examination, I chose to go because I am not qualified. No question was put to me.
Okay. Heard 3 SD. Learned, yes, anything? Learned counsel for the petitioner who is aggrieved by the action of the respondent authorities in holding him to be disqualified from participation in the recruitment process initiated by the advertisement dated 30/12/2024 for filling up of the post of lecturer within bracket non-technical
My lord.
in polytechnics
Yes.
in the state of Assam. Full stop. It is the case of the petitioner that he is an MBA qualified person, correct? He possesses the MBA degree and is duly qualified to hold such post. Full stop. Para. Let notice be issued. Returnable. Yes, when? Returnable by 4 weeks. 3 das. Yeah, for all.
I'll be paying for my lord,
1, 2.
1 and 2, my lord, for 3 and 4,
K Gogoi.
for 3 and 4.
Is he there or not? Okay. As thus for 1 and 2, K Gogoi 3 and 4 extra copies.
If one to get vacant, otherwise third party right.
That be already out of.
But you're allowed to sit, my lord. The
Now,
last similarly qualified person allowed where.
let us see. Let us see. Sri, day praise for an interim order. Tara. Under the facts and circumstances, a blanket interim order is not called for. Full stop. However, it is made clear that if the petitioner is successful in this writ petition, comma, he will be entitled to consequential reliefs.
Must apply.
Hey, Peter. Matter relates to non-provincialization of lower primary school. The petitioner school not provincialized on the ground that petitioner school have not transferred for the year 2009
Yes,
and
yes,
10.
instructions, madam. Instructions, affidavit filed. There is an amended cost title.
Yes, already
filed.
filed.
Where is your affidavit?
Okay.
Huh? 22 matter, you should file affidavit. Whose name?
M. Selim.
Okay. Why was this amended cost title required?
Because earlier Sarvashiksha director of Sarvashiksha was not made party.
Oh.
Now,
What is your name?
M. Selim.
Sri M. Selim, learned counsel for the petitioner, has submitted that pursuant to the order dated 10/2/2025 passed in IA 10 of 2025, an amended cost title has been filed. Full stop. It, however, appears that in spite of the earlier orders, in spite of the earlier order of this court dated 28/5/2025, the name of the Learned Standing Council SSA has not been reflected in the cause list. Para? Miss Anne Fukan, Learned Standing Council, Education Department, however, praised for time to obtain time to file affidavit in opposition. Para? List after 3 weeks to enable filing of affidavit in opposition. The name of the Learned Standing Council SSA be reflected in the cause list. Who is there, SSA? As Barab, kindly inform him. Okay, and he can also file affidavit. Is he around? We can record his presence. No, he needs to take instructions also. Okay.
Hello,
Yes,
kindly fix the date.
Tell us, list on 24th of June. Hopefully to sit on board. 16. Instructions are there. Yes, Madam Talukdar, what is this?
Matter of non-regular of the subset of the pit as the city teacher logic and philosophy agreed by tune order that page
Just a minute. What is your name, Madam? Abed Ali. It was rejected earlier.
there was direct court to the matter and thereafter the tune order has been passed. And challenging.
Reason order has already been passed, Your Lordship. Page 76, that is annexure U. Finding is there, Your. With highlighted points, Your Lordship.
What is your challenge, Madam Talukdar? Are you challenging which order are you putting to challenge?
It is here my post is converted from admit search post is dying vacant.
No,
So
but
that-
there is an order
Not-
of which appears to have been passed on 14/5/2023, rejecting your case. That has not has that been challenged? Have you challenged
Not
14?
that is challenge specific.
No, that is then perhaps this is not the instructions. This is the matter of challenge already.
Pertaining to it, Your Lordship, I have written, Your Lordship, and here, Your Lordship, they have clearly stated that on the very last paragraph, therefore.
No, that is the subject matter of challenge. You cannot take up the impugned order to justify your action.
I may allow to file our affidavit, Your Lordship.
You bring on record. This is an instruction of 2023.
Up to date with instruction. Thereafter, I would like to file our.
You file your affidavit.
Yes.
Heard Miss A. Talukdar, Learned Counsel for the petitioner. Also heard Miss P. Das, Learned Standing Counsel, Secondary Education Department, who prays for and is granted 3 weeks time to file the affidavit in opposition. List after 3 weeks.
Pray for a date.
List on 25th, 25/6.
Not of that. DP of it.
18. Item 18. Yes.
I thought this is second round of petition method, parties not to the subject of the petition method. Fact that the petitioner can not the private respondent.
Yes, affidavit in opposition filed.
No, fact, not, the private.
Education
has not filed,
Department?
The government has not filed.
You filed an affidavit, your time, given time on the last occasion, 17/2 also.
Due to interim order passed to the private respondent in accepting order.
Is there any interim restriction?
Yeah, therefore, the matter taken as
Where is the restriction? Which order?
He has filed a vacation petition.
Vacation petition dismissed.
no, that the
The benefit of provincialization was directed not to be given to you by the order dated 1/12/2023. Okay, you get, madam, get the instruction. You have to decide this matter. Okay. Time was granted to the department to file the affidavit. Such affidavit has not yet been filed. Full stop. The respondent number 6 has however filed the affidavit in opposition. Para. On the prayer of Miss S. Moore, Learned Standing Counsel, Elementary Education Department, a last opportunity of 2 weeks. Madam, 2 weeks is granted to file the affidavit in opposition, failing which this court would proceed with the matter. List on 25th, no, 2 weeks we have given, not 25th. List on 19th of June.
Hello.
Item 19.
May 3, Your Lordship. Kindly you produce order dated 29/1/2025.
Yes.
If it is a covered matter, Lordship. On several occasions, the Finance Department took time to find.
You are referring to 8694.
Lordship, yes, Lord.
Yes.
Lordship, here we have received a instruction. Here the Finance Department has stated if the entries after 1st of every 2005, Lordship, they will govern by the new pension. And if they are to be governed by the old pension scheme, that has to be identified by the education department. That is because they are the employer. So at this, if need be, Lordship, you can file an affidavit.
Let us see the affidavit. Hardsby, your Peabody lawyer.
Lordship.
Learned Counsel for the petitioner who submits that the matter is covered by the decision taken in WPC 8694 of 2018. Full stop. On the other hand, Sri A. Chaliha, Learned Standing Counsel, Education Department, Finance Department, has submitted that written instructions have been received on 17/3/2025, as per which the contention of the petitioner may not be correct.
Yes.
Full stop. He accordingly prays for some time to file affidavit in opposition. Let such affidavit in opposition be filed within a period of 3 weeks from today.
Can I have a copy of?
This is written instructions. Next.
Obliged.
On 19th, I have
Which matter?
item number 18.
Yes, who is for the other side? Yes, tell us a date. You should tell at that time only. On we'll have it on 18th then, 18th. Not 18th, 20th, 2020. Bistari. Kune asilo etu? Bistari. 23.
Hello, it relates to cash promotion. The government have given a decision that giving a promotion with effect from March 24. By this time, the petitioner is retired in 23. So, my promotion was due in 2019.
I prayed my lord, so personal promotion to be given and the other.
Yes, notice was issued. What are your instructions?
fine. That-
Okay, and Pavel? File your affidavit. Notice was issued. Thereafter, matter had come on.
I thought interim prayer my lord, the petitioner is attempting to get some money, area MM that is being paid. So I say that this be considered. There is no bar to consider this payment.
Let them file affidavit. On the prayer of Sri Tavildar, Learned Council, Sitting Council, Higher Education, as well as Miss Bora, P. Bora, Learned Council for response number 3. 4 weeks' time is granted to file the affidavit in opposition.
Hello, there is a prayer method, the interim area salary is to.
Interim prayer was considered on the first date. Was it considered?
But I have not receiving that amount.
Yes, what is your instruction?
If we file affidavit, I have not been paid.
Penancy. Till on the next date fixed, comma. Instructions are also directed to be taken on the aspect of release of the arrear salaries. Full stop. It is also made clear that if there is no bar, if the petitioner is legally entitled to decide, the same should be released.
Apply.
24.
Mr. Chalia. If a notice was issued.
My lord,
But petitioner says that DB 255 APA writ appeal covers it.
yes. By your lord. That I had.
You take instructions, file affidavit. Heart Street DP Chalia Learned Senior Counsel assisted by Ms. Emroy for the petitioners. Full stop. Para 3 G Pegu Learned Standing Council Elementary Education Department, however, prays for and is granted 3 weeks time to file the affidavit in opposition. Yes, you want a date, Mr. Chalia? List on 25th of June, 25/6.
Right.
25.
So here the matter is related to overstay. The petitioner already been released from service, but the prayer is that his GPF amount that has been whatever amount is due, it is already deducted till the date of his releasing. But amount has been paid calculating till the date of his actual date of retirement. The petitioner's wife is suffering with a cancer patient. So my prayer is that I'll give ready to give any undertaking, to the authority concerned. Money should be
Yes,
paid.
what are your instructions? In what capacity did you retire?
As a UD.
UD, yes.
Is the college
yes, authorities. Mr. Boro.
Respect me.
I have received instruction here. But with regard to state more time in the
overstay.
That is
overstay. It is regard to the we have written to the department. That period has not been recognized. So we have written to the department that if they recognize, then only we can.
I think department has to take a call. They are the implementing agency, AG.
The prayer is that is not within that. At least 21.
No, AG will do whatever they will do on your instructions. No,
I am ready to give any undertaking. My wife is badly suffering from cancer. So I require the money. 2 lakh something amount is been still pending.
Heart Sri P. Mahanto Learned Counsel for the petitioner who submits that notice was issued on 12/2/2025 and there is certain urgency owing to the ailment of the wife of the petitioner. Tara? 3. Tawildar, Learned Standing Council, Education Department, prays for some time to obtain instructions. First of para. List on, give a date. His emergency. List on.
In June, my lord, probably on
List on 19th of June.
19.
19. Take the instruction.
Okay.
We record the presence, Mr. Boro. You're for whom? AG? 4, 5, and 6, and P. Bora. Huh?
This was in discussion.
Item number?
Item number 26.
What is the cause of action, Mr. Kolita?
Matter pertaining to increment to the petitioner.
Okay.
Petitioner
Part
join in
3, M. Kolita, Learned Counsel for the petitioner. In this case, for the petitioner, for para. Notice was issued on 14/2/2025. Para. However, time has been sought for on behalf of Ms. R.B. Bora, Learned Standing Council, BTC, for filing affidavit in opposition. List after 4 weeks. You are for? You, sir, we know your name. What 1 and 2 is what? Who are 1 and 2? Education Department. You, Sharma, huh? Secondary Education. Your affidavit would also be necessary. Your affidavit would be necessary or not? Or do it,
Item 27.
In this matter, when the notice of motion was issued on 10th of March,
yes,
it was observed that the interim order will be considered on the next day. Thereafter, my lord, 2 days have passed by. They said that we file affidavit. Till now, the affidavit has been filed.
First you tell us your association is new. The polytechnics are new.
Both.
Huh?
In fact, polytechnics were
Or
open.
there is another association you have formed, a rebel association.
My lord,
What is your name? New Engineering.
Yes.
And
New
Polytechnic
Engineering and-
Faculty Association of Assam. It can give various meanings.
There is an old one.
Old one. The engineering college is a new one. And you may be having a new thinking.
My lord, perhaps that will be the correct, my lord. Yes, new thing.
New thinking.
They were appointed, my lord, these politics.
Yes, yes, Mr. Das.
The affidavit filed and in fact,
Affidavit filed.
has filed that
We can have this for admission hearing. You have filed reply also. You have filed reply, Mr. Chaudhary. Ask your assisting counsel. Mriganka Sharma. Filed by who? It was filed on 28 March 2025.
Yes, I'm sorry.
The pleadings are complete and the matter can be taken up for admission. First up, as requested, list for admission on when? 11th of June? 11 June. Mr. Saikya, for which matter? We thought this matter. There is new thinking of engineering.
Yeah. Lordship, in item 38, we have been served a copy of the affidavit today. We have
38, you are there?
Yes, sir.
Oh, Hunch is correct.
So let it come after 2 weeks, Lord.
2 weeks is a long time. my
Maybe after 1 week.
Yes.
2 weeks is a long time.
Yes, my lord. Because
In what context?
because they are not, my lord, receiving the arrears salary. One is not receiving salary from day one, my lord. In
Yes,
spite
Mr.
of the
Secretary, why don't you pay the arrear salaries if they are serving?
There are some seriously. That's why
But if they are serving, serious issues may be there.
had it been a simple case, they would, all the other contemporaries of the other districts and their districts, they have received it long time back.
Here is a case, my lord, where we.
Oh,
my
this
lord,
is a contempt matter.
Yes, my lord. We asked for the salaries, my lord. This honorable court gave the direction to pay salaries. Then, my lord, there was review, there was appeal, there was SLP, my lord. Everything has been dismissed. And my lord,
Then contempt, where is the of again adjudicating?
No, let it come next week along with my.
Okay, you have filed the affidavit.
Yes.
Today we have been served a copy.
Okay. Okay, next week then. Heard 3 M.K. Chaudhary, learned senior counsel for the petitioners. Also heard 3 D. Sekia, learned senior counsel for the respondents.
I can appear as AZ also because there is a constitution bench judgment. As senior advocate also, it's okay.
Appear as senior advocate for all the respondents. Who submits that affidavit in opposition has been filed today? Full stop. Para.
4 and 5.
List on next Wednesday?
Yes, sir.
We'll give the date. Today is 2nd. We'll have it on 11th. 11th June. The affidavit said to have been filed be connected, be tagged with the records.
Hello.
Item 29.
It the last page of the separate full code. But reading for the director. Here, madam, last occasion it was applied that the proposal for Vietnam Port and the SI approval has been sent to the madam government. Pending for the for some time.
Government means?
The
Education Department.
Education.
Who's appearing? His contempt matter. Education Department Secretary.
Secretary madam is not a part.
Then?
It's already the right.
None appears for the petitioner on call. Para. 3. B. Kaushik, learned counsel for the respondent, has, however, submitted that the director has sent the proposal to the department for consideration. Full stop. Para. Be that as it may, in absence of the learned counsel for the petitioner, matter is adjourned to be listed after 2 weeks.
Item 40 and 41.
40 and 41, my lord, here the first provisional list was published, my lord, and there were the objections called from the candidates. And thereafter, my lord, because of this, the NIOS candidates has been included. My lord, second provisional list is also been published. Now, my lord, after we meet the objections, my lord, and petition is done, we can go ahead with the pipeline.
Yes, what do you say?
Lordship, let it be on. Let it be after 2 weeks. 2 weeks will be very long because 2020.
3. B. Kaushik, learned counsel for the respondents 1 and 2, has submitted that there are certain developments towards compliance of the order in question. Full stop. He accordingly prays for and is granted 2 weeks time.
Great. Not a date may be what is possible.
2 weeks, we have said 2 weeks.
42.
Yes.
Right.
Lord, the
What
order
the
passed
matter?
by the noble court, Lordship will find at page 40.
Well, in this, we have completed appeal. Madam Capital, it's for the matter. And this because we have filed also an affidavit.
The filing of appeal is not an excuse unless there is an interim order by the appellate court.
Appeal listed for the matter.
No, appeal will be listed. That is in the air. It is contemplation. We do not even know whether the appeal will be admitted or not. What have you done towards compliance of the order in question? Have you filed affidavit here?
Yes.
What is the direction?
My Lord, page 50, Lordship will find. Page
Direction
50.
for?
Direction for pay the Miller salary. Since 2013, our salary is not paid.
When did you file the appeal?
Madam, challenging the order.
When did you file?
Appeal filed on, my Lord,
Yes,
6/5/2025.
6/5, not listed as yet.
Yes, ma'am.
And order was, my Lord, on 1/12/2020.
Three, U. Sharma, learned counsel for the respondent number 5 has submitted that against the order in question, an appeal has been filed on 6/5/2025, which is likely to be listed for consideration soon. Full stop. Para. In view of the above and in the interest of justice, consideration of this matter is deferred by 2 weeks.
2 weeks.
Yes, after that, if you do not, then we'll adjudicate. Mere filing is not a reason.
Obliged.
Forty-three, contempt, yes. None appears for the petitioner on call. In the interest of justice, list after 2 weeks.
45.
Yes, what is this? On the last occasion, you took time because of panchayat elections. Now elections are over.
Lordship, here we have a instruction that department is taken to authenticate the petitioner applicant, and they said that they will tell the petition court in all the data we have.
They are taking certain steps. We'll grant some time. What is your name? D. Nath.
Correspondent from
3. So-and-so learned counsel appearing on instruction of 3 D. Nath. Counsel for respondent number 1 has submitted that written instructions have been received via communication dated 31/5/2025, as per which steps are being taken for compliance of the order in question. Full stop. He accordingly prays for and is granted 2 weeks further time to get the up-to-date instructions. List after 2 weeks. Mr. Chisti, you are appearing for somebody. Oh, Assembly Chisti, respond number 2. Mr. Goswami, which matter?
46.
Review.
Yes. This is the second round. The first round, your lordship went into the matter and dismissed the petition because it was not eligibility condition, the number of vehicles. Then division bench affirmed your lordship's order. Then the petitioner went Supreme Court. Notice was initially issued. And afterwards, we were given the permission to inspect the record, because by that time the records were there. It is on inspection of the report, we saw certain discrepancies with regard to the eligibility of experience, which is an eligibility.
But the work is still undergoing, is still alive.
Yes, it's a mission, Milord, for mobile medical treatment in rural areas in Assam. It's a huge responsibility. Therefore,
What is the tenure of the work?
That 3 years, the new tenure who started, it was given in favor of the respondent, but they could not mobilize and come within the time. 90 days is the period given under the tender term. They were not in a position to give that, and we were asked to continue, and we are continuing. There's no problem with that. But the discovery
Yes,
of
Mr.
the-
Gogoi.
But so far as the present contract is concerned, initially it was the private respondent was allotted the work, but before he could resume the work or he could start the work, there were stay orders in this particular petition, and it continued with the honorable. Now, my lord, the honorable court has finally, my lord, upheld the order of this honorable. Thereafter, now they have come up with it. For last, my lord, from 2023, because of the stay order operating, with the petitioner who is enjoying the is still continuing. And my lord, this cannot be a
Stay
ground.
order operating means this writ
There
was
was a
dismissed.
status order
Status
issued on
order issued by the Supreme Court.
and they went to division bench and some protection.
Because the documents will reveal, Milord, that there was a fraud played. And fraud, Milord, demolishes everything.
Did you approach the division bench?
I did, Milord. The initial application was filed before the division bench.
Okay, we'll issue notice at this stage.
Yes, your lordship can.
Ultimately, the work is.
No, we are not
No,
passing any
it is
interim order.
continuing. NHM has.
Heard Sri P.K. Goswami, Learned Senior Counsel, assisted by G. Goswami. Assisted by Ms. G. Goswami, for the applicant who has filed this application for review of the judgment and order dated 4/5/2023, passed in WPC 2049/2023, full stop. It is submitted that though this order was affirmed by the division bench and also by the Honorable Supreme Court, pursuant to certain directions whereby inspection was permitted, was directed to be permitted, the applicant has discovered certain new documents which, according to the petitioner, would have a bearing in the decision taken by this court, a material bearing. Tara? On the other hand, Sri B. Gogoi, Learned Standing Counsel, Health, NHM has submitted that
My submission will be my lord, for the honorable Supreme Court, they were given the opportunity to verify the record. And the honorable Supreme Court, after when all these things were pointed out, for the honorable Supreme Court, and a query was
has submitted that before the Honorable Supreme Court, the petitioner the applicant was granted, was permitted to verify the records. And all along, because of certain interim orders, the petitioner the work has not been able to be allotted to the successful bidder.
The other part, my lord, the honorable, after printing the record, was dismissed the
That has not become. It doesn't
He has
become
also
very
submitted
critical.
that after dismissal of the SLP, the present review would not be maintainable.
Yes.
Para? The aforesaid aspect would be considered. Para, let notice be issued, returnable. We give a date, Mr. Goswami?
Any convenient paper. After you that work.
It's been soon, is that?
No. Soon I
16th of July. 16th of July. 16th of July 2025. Sri B. Gogoi, the learned standing counsel, accepts notice on behalf of
What?
1, 2, 3, and 4.
4 no, private.
1, 2, 3. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent number 4 by registered post with AD. Steps by tomorrow. Madam, do not leave something in the blank in the copy filed. If you put page numbers after the annexures, fill up the page numbers. Otherwise, don't put page numbers. Okay.
Let us go.
That
will be difficult.
So the benefit
In a review, it will be difficult.
The interim order was considered by your government.
Is there any IA?
Yes, yes.
IA?
We have prayer.
You file an IA, we'll consider it.
Otherwise, it may affect the entire rural field.
No, there should not be discontinuation.
That is what my concern is. Because they, in their review meetings, they have been giving them extension of time after time. They have not been able to.
Okay, let us see. We'll see your new documents. No, we'll see the new documents, whether it says a material bearing. Okay.
We have communicated with the state authorities, matter of Odisha. I have done everything.
Okay. 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 47 to who it is? Or 47 it will be. 47, yes. Mr. Bora.
Not complete respondent number 2. If reliably learned that respondent number 2 has changed.
You need time to file implement or what?
Implement, completing the new.
Okay. On the prayer of Sri BP Bora, learned counsel for the petitioner. 4 weeks time is granted to file appropriate IA for implement of new incumbent. But before you do that, you know what to do. Issue notice on your own and NXD postal receipt. Otherwise, you will not implement.
Yes.
You have to notify.
Oh, yes. Will inform.
49.
Yes, Mr. Das.
In respect of order to the 11.
Contempt.
Contempt.
Notice was issued, yes. Neither ID card nor sole respondent. No.
For the same set of allegations, they have called for his hearing.
Who is the respondent?
Only sole respondent. That direct.
Mr. Sisti, you obtain instruction unofficially.
Yes.
We cannot ask you to appear. Okay. Hard 3 SK Das, learned counsel for the petitioner. Full stop. In this case, notice was issued on 24/3/2025. Full stop. Office note dated 29/5/2025 has, however, reflected that neither AD card nor unserved notice has returned back from the sole respondent. Para, in view of the above, the matter is adjourned by a period of further 3 weeks. You take note of this.
Yes, but there is some evidence. Already I have been.
No, without steps being complete, what can you do? How can we ask him to appear? It's a contempt matter. Till then, we have asked him to take informally. We cannot do that. You know what are our limitations. Contempt matter. 3 weeks, you have said. You give him an extra copy just informally, if he is allowed.
All right.
Mr. Borbia. Affidavit, you'll file affidavit. Okay. He has entered appearance. Hard Sri F.U. Borbia, learned counsel for the petitioner. Put the para. Sri P.J. Fukan, learned counsel, has submitted that he has entered appearance on behalf of the respondent number One respondents.
All.
Full stop. He prays for and accordingly is granted time of 4 weeks to file the affidavit in opposition.
That's the matter. So it's my learned.
Pension matter.
Pension.
3 weeks. 3 weeks.
Taking a date, sir.
3 weeks, file 3 weeks. The name of three PGF who can be reflected in the cause list as
Obliged.
counsel for the respondent. Yes, next. Mr. Khan,
This case lordship,
notice was issued.
the district dispute uniformity as well as the state dispute.
Learned counsel has entered appearance. Madam, you went to. What about 3? 3 also you're appearing.
I am prepared.
2 and 3.
Only prepared.
2 and 1. Who is 1? Director.
Secretary lordship. Secretary of Secondary Department of Disciplinary.
Yes, Secretary. Mr. District, take instruction. Okay. Heard 3 M. Khan, learned counsel for the petitioner who submits that notice was issued on 8/4/2025. Para. Office note dated 29/5/2025 has reflected that respondent numbers 2 and 3 have entered appearance through learned counsel, and AD card has returned for respondent number 4. Full stop. In fact, Miss, you are for respondent number 3. Who about what about 2? 2 and 4? 4 AD card has returned. Who is 4?
Chairman of Joint Committee.
Name?
RC Joy.
Oh. 3 A. Chalia, learned counsel has entered appearance for respondent number 2, whereas Miss S. Chutia, learned counsel, is present for the respondent number 3. Let their names be reflected in the cause list. Let the matter be listed after 3 weeks, by which time the respondent numbers 2 and 3 may file their affidavit and the office may give an updated report regarding the service upon respondent number 1. Yes, 1 and 4, Mr.
My daughter.
4 you cannot. Okay. Yes.
He is in the path of rejection, lordship. May I pray for a date?
What is the the direction?
Direction to provincialize the service of the petitioner within 45 days.
When are you retiring? 27.
My lord, now 57 here.
Well, that is it. 27 you are retiring.
He has not.
What is the verge of retirement? We thought maybe next month. Yes, next. Huh? Unlisted. None দেখুন কি বল 2টা বজাত 22 2 বজাত আহিম বলে We'll sit at 2 o'clock. There is an unlisted matter along with 22. One.
First, I will place the unlisted one.
Unlisted. 3018.
Yes.
Yes.
Matter relates to selection or appointment of principal in Madrasa College. The case is going on since 2021. There was an advertisement, my lord, at Annex 9, page 50. Then, my lord, sorry, page 46 on 21/2/2021. I also applied. Then I am duly qualified and I am also the examiner of PhD degree. So, got the appeared in the PhD examination. So I am also designated by the university to be an examiner. My lord, I would more than 110 publications, research publications. Also, my lord, then my lord, there was an advertisement. I applied. There are 3 others applied. That you lost to kindly find, because here API mark this score is important. I have the highest API mark. You lost to kindly come to page 10. Sorry, 86, annexure 10.
Annexure 10, page
86.
86.
That the PhD and other experience for 15 years of experience, my lord. This is important, madam. Page 86, I am at serial number 1. Dr. Muhammad Amin Hassan. My API total mark is 242.1. And there is no any adverse remark in the remark form. Others have adverse remark. They do not have publication of required number of publications. And the third one was
Now, what is your grievance?
Grievance, my lord, I am coming. Third one, Azur Rahman was selected.
Yes.
Selected. But he also doesn't have the qualification, yet he was selected, but he died. Then, my lord, this Islam, he didn't come. So I should get, because I have the highest API mark.
But is the selection done only on the basis of API marks?
And qualification.
And qualification.
And 15 years minimum experience.
Okay.
In the higher education. That is a, my lord, as per the UGC norms of 2018. I very the relevant portion of the year. Then, well, they didn't appoint me. I filed the case. Case is, my lord, I'll now come to case 90.
19.
No, 90.
90.
Case 13. Yes. Thank
You filed 4683.
Yes. And order is 27 July 2022. Here, the government took the stand that the select list is it to be approved by the Director of Higher Education. Page 92. And based on that, my merit is not dismissed with the observation, ultimate para of page 92, my lord. In that view of the matter, I do not merit, I find no merit in the present petition, and the same is according to speech. However, the director is directed to pass a final order after taking into consideration the minimum eligibility qualification prescribed in the advertisement dated 21/2/2021 and in accordance with the law. Well, this is yet to be complied with. Whether earlier selection should be done away with or not, direct is yet to approve or disapprove the selected. And now I am the lone candidate left out. And I got the highest qualification among all, with 111 mileage research paper publication. More than others, far more than. Now, they have recently issued the advertisement and appointment issued without direct approval.
Appointment issued means to whom?
To Azur Rahman. He died.
No, he died, that you had said.
He got. The other one didn't come. Now, they have issued advertisement, my lord. Before my case is decided with the director, is my lord 114, NSO 21. That's what I am telling now.
100?
14, 114.
Yes.
Here I fulfill this qualification number 1, PhD I've got. Yes. And my lord, PhD, I worked as assistant professor, a minimum score of API marks is important.
Yes.
Then my minimum research, 10 research publications. in peer review.
No, that is okay. Now, what are your grounds of challenge? Where have you challenged?
Ground is my mother, before the director decides my fate, in terms of the 2021 advertisement, they could not wish to decide. That's why I'm telling you. I could order also there to take a decision on that. They haven't taken any.
No,
Let them decide.
But if somebody had already joined, the selection process came to an end.
No, he could not join. He fell ill and he died.
No, a selection process will culminate on one point. You said
Never
the
come, Malak, because-
selected person had passed away. Azizur.
Yes, he passed.
He's passed away.
Ah.
When did he pass away?
I think he passed away. Good joining.
Your main contention is that 27/7/2022 order should be complied with.
Yes.
First.
Yes.
Then
only if they reject my case, because I'm the load candidate.
okay, have you taken any decision on 27/7?
Has been appointed.
Appointed? When? If he's appointed, matter ends there.
No matter, because that is not a challenge. His selection without being qualified. That is a challenge in item 22.
Now that you can challenge. That challenge, we are not saying that challenge is not maintainable.
Yes.
If an unqualified person has been selected and appointed,
yes,
you may have a better case.
That is pending.
But during that challenge, that challenge is in the other case, 5045.
Yes. So
50,
item 25.
but he has passed away in the meantime.
Passed away.
But since the candidate has expired, that entire process is the principal select direct and they have been in order that
my
Yes, Mr. You are for whom?
for governing purpose.
Governing body.
He might have the information when he died.
When did he join? Did he join?
Make up the compilation of papers.
You tell us what is it?
Well, I have compiled every paper.
Ahmed for which? Whom? Your M. Ahmed.
Emma,
For governing body.
for governing. Basically, challenge the private respondent.
Here there is a private respondent in a new petition.
No, Lord. In the earlier petition, Lord, it was
5045.
504. So on the ground that was not qualified and was not qualified, holding him hindered by the government illegal. The phase lordship that
Yes. Four years.
has annexed the petition.
Yes, yes.
Phase of whole lot.
Yes.
This is the Lord academic score lot.
Hmm.
Now, Lord, if I kindly come to last paragraph.
Yes.
First, this could has been evaluated based on 2018 regulation and as per the research made by candidate supported application form on the basis of the academic research could evaluated the following applicant may be shortlisted. Original document. Now, this is shortlisted candidate. So, in the shortlisted candidate, the name of Dr.
Yes.
Now, so far as API is concerned, it has got the twins. First, got the contract.
No, Mr. Ahmed, why are you going back? We are on the fresh writ petition, in which the present advertisement dated
21, what is the advertisement?
29.5.
29.5 is put to challenge.
Yes.
Now, 29.5 is the cause of action here. We are not on the earlier writ petition. Earlier writ petition, in fact, that selected person, he has passed away.
Yes, sir.
He is trying to make out a case that since the number one candidate against whom he had a grievance, existing grievance, writ petition still pending, had passed away. So if he's next in the line, he should be given the appointment instead of going for a fresh recruitment process. That is precisely his case.
Yes.
What is your take on that? How do you respond?
Now, to response to that, Lordship, here the selection be recommended the name of the private person, qualification.
Yes.
Pursuant to that recommendation. And while recommending this private person, private person, the name of the private person was only recommended. There was no waiting list, nothing. 3 persons appeared in the interview, and among the 3 persons, this person scored the highest mark in the second. By this second, second one is another person. The petitioner was third. Now, Lordship, kindly come to thereafter, Lordship, the appointment letter was issued. And once the appointment
When
letter
was the date?
issued,
What is the date?
appointment was issued on Lordship 28
28?
2008-2020.
28, 24 days. Azizur was appointed.
Yes, sir. On the basis of the selection.
When did he pass away?
He passed away May 3rd.
This
come to page number 41.
This year?
Yes, sir. (13 to 2020), page number 41.
Yes.
Page number 40. This is the letter written by the governing to the director seeking permission fresh advocates with post. And on the basis of this letter, next page, page number 40. Here, Lord, we have elaborately stated that once the process was started of the advertisement, that has culminated the issuance of the appointment. And therefore, Lord, we paid for fresh advertisement, and that approval has been given at page 40. Page number 42, the approval letter. And plus one outer by the director, and outer limit of 45 days has fixed from the entire process. And then first 120.
Okay, we have got your case. Yes, yes, anything? What are the rules?
Rules are no, provision of waiting list is not there. The Assam College and 10. Method of picking Rule 5. Appointment post of this is
Yes.
appointment.
Yes, please read. Yes.
Method of recruitment. Recruitment shall be made in the manner prescribed therein. Appointment of principal shall be by direct selection. For this, the governing body shall constitute a selection committee which shall select a person
on the basis of an interest
Hmm.
from the amongst eligible candidates to apply in response of an advertisement in newspaper. The governing body shall recommend the candidate to the director who shall be ordered to
Hmm.
thereafter to other etc. And come to accept.
Yes, please.
All appointment either by direct recruitment or promotion shall be made by the director on the basis of the recommendation of the governing, based on the recommendation of the selection committee, but the promotion committee duty counts.
Hmm.
Here versus the selection committee in name of that private respondent.
Hmm.
And for it may kindly come to page number 18 for
18. Yes.
of the compile.
Please read. Please read.
This is the consolidated statement, Lordship, of the marks obtained by the candidates who appeared in the interview.
Yes.
In as much as 33 persons were appeared in the interview. Number 1, Dr. Akhtarul Islam. His average mark was 51.1. Number 2, Dr. Azibur Rahman. His average mark was 57.97. Selected. Number 3 was absent. Number 4, Dr. Yamin Hassan. That is the petition. His average mark 44 on. And Lordship, if Lordship kindly come to page number 27, this is the record of selection. Last paragraph, Lordship.
Yes.
In the first paragraph, the body of the entire selection committee is there, starting from the chairman. And I'm reading the second paragraph. The selection committee interviewed 3 candidates who had turned up for the interview out of total 4 applicants for the post of principal.
Hmm.
The committee interviewed the candidates, examined the documents and testimonials, verified the constitution of marks of each of the candidates. It was then decided to resolve that Dr. Azibur Rahman be selected for the post of.
Now, where is the rule? You are saying that there rules and does not envisage there is no rule for no select list, no waiting list. Hmm? দেখুন না। Where is FRBM? Now you're saying FRBM. After all this, we are asking for FRBM only. This is what we are looking all this time. Where are the rules? This is the FRBM Act, 2005. Where are the rules? Should show the appropriate rules if you are knowing that the FRBM exists. Rules আছে এটা। 2 পেজ 2-3 পেজের রুলস আছে নেটত চাই আছে এখন অ্যাক্ট হয়। And the earlier writ petition was pertaining to what? 5045? The
No,
one
yes, same, my lord.
No, item 22 is pertaining to what?
Challenging the.
Oh,
appointment.
Azizur's appointment.
Yes.
Okay.
No, not only his, the entire selection process, because non-qualified candidate and claiming my appointment.
Okay.
This petition, now it stands that the appointment was approved by the DAC. It was approved by the DAC.
Well, you participate in the new selection. Chances of getting relief.
Hello?
Chances of getting relief in this is very less.
No, my lord. Since I think if you'll also again come to page, next 10, page 86.
No, without even going into that, after the FRBM rules, there is no concept of any waitlisted candidate.
No,
And what-
I'm not telling you what it is.
No, if you are
I'm telling you the
if you
entire
are
selection.
challenging the entire selection after passing away of the selected candidate, the selection process has gone.
I tell you before passing of
Now,
the.
if this new advertisement you are challenging on the basis of the earlier,
Yes.
we cannot stay this. You participate in this.
Because my lord, I have challenged the election in the sense, my lord, that except me or other disqualified, if you will also come to next 10, they would not be even invited for my lord selection process. Even if test for on merit. Total violation of the my lord UGC norm, UGC regulation.
Difficult. Okay.
Because only even the selection committee, as per rule 10,
We'll issue notice at this stage and you participate, we'll say it will depend on the outcome. We'll not stay this. Okay. Heard. Sri R.P. Sharma, learned senior counsel for the petitioner. Full stop. This petition has been moved by taking special permission as the same is connected with WPC 5045/2024, which has been listed today. Para. As per the facts projected, pursuant to an advertisement dated 21/2/2021 for the post of principal, Mankachar College, the petitioner, along with 3 other candidates, had participated. Full stop. The petitioner claims that he was the best amongst the lot with an API score of 241.1.
242.1.
242.1, whereas the other 3 candidates were having lesser API score, and he has also drawn the attention of this court to the evaluation sheet, which contains certain adverse remarks against the other candidates. Full stop.
Regarding their qualification.
Other candidates with regard to their qualification.
Yes.
Full stop. Be that as it may, comma. One Dr. Azizur Rahman was selected in place of the petitioner, leading to filing of WPC 5045 of 2024. Full stop. However, during the pendency of the said case, the present advertisement has been published on 29/5/2025 for the said post, inasmuch as the earlier incumbent, Dr. Azizur Rahman, Azibur Rahman, had passed away in the meantime. Full stop. The learned senior counsel has submitted that in the year 2022 itself, he had filed WPC 4683 of 2022, which was disposed of by order dated 27.
It is pending.
Oh,
Early one was this.
No, Lordship, 482 was papered by the present petition.
No, that was disposed of 27/7/2022.
No, it's earlier.
Earlier only we were saying.
This is pending.
We know that is pending. We are talking about 4683.
Yes.
Please kindly listen to what this court is saying. Don't just. Itself, he had filed WPC 4683 of 2022 in connection with the said selection in footstep. However, the said writ petition was disposed of via an order dated 27/7/2022, dismissing the writ petition. However, with an observation that final decisions were to be taken by the director. Full stop.
As per his it is taken
And full stop. It is after that direction, after that order, that final decisions were taken leading to the appointment of Sri Ajibur Rahman. Ajibur Rahman. Full stop. Para. The learned senior counsel has submitted that after expiry of the earlier incumbent, it is the duty of the authorities to appoint the petitioner in the said post as he has better qualifications. And on the other hand, they have issued the impugned advertisement dated 29/5/2025. Para. Per contra, comma, Sri M. Rahman, M. Ahmed, learned counsel appearing for the governing body, has submitted that as per instructions received in the first selection process initiated by advertisement dated 21/2/2021, only one candidate, that is Azizur Rahman, was recommended, which did not, and the said list did not have any other names. Full stop. He submits that even by way of merit, the petitioner was third, and above him there was another candidate. Full stop. He further submits that the earlier incumbent, Azizur Rahman, was appointed on 28/2024, and unfortunately, the said incumbent had passed away on 13/2/2025, leaving the post vacant, and therefore a request was made by the governing body on 24/2/2025 to the Director of Higher Education, seeking permission to issue a fresh advertisement, which has accordingly been done on 29/5/2025. Full stop. He accordingly submits that there is no merit at all in this case. Para. Sri S. Das, Learned Counsel, Learned Standing Counsel, Higher Education Department, while endorsing the submission of Sri Ahmed, has also placed before this court the Assam FRBM Act 2005, more specifically Section 7 within bracket small g, or small 71, 1771G, as per which there is a mandate to have a select list for select list which is equal in number to the vacant post, and in the instant case, the vacancy being one, only the select list was only of one candidate. Full stop. He has further submitted that once the appointment was made on 28/2024, the recruitment process had come to an end, and any subsequent vacancies would have to be filled up by a fresh selection process, which is the mandate of law. Para. The rival submissions have been considered. Para. Let notice be issued, returnable by 4 weeks. Sri S. Das, Learned Standing Council, Higher Education Department, appears, accepts notice on behalf of respondent numbers 1 and 2. UGC. Sri R. Bhuya, Learned Council, appearing on instruction of Sri A. Chamwa, accepts notice on behalf of respondent number 3, UGC. Sri M. Ahmed, Learned Council, appears for the governing body.
4 and 5.
4 and 5.
Not 4.
Who is 5? Selection committee. Okay. Sri P.J. Fukan, Learned Standing Council, Guwahati University, accepts notice on behalf of respondent number 5. Let extra copies be served upon the Learned Council for the respondents by tomorrow. Para. Sri Sharma, the Learned Senior Council, prays for an interim order. Full stop. After consideration of the rival submissions and also taking into consideration the Assam FRBM Act of 2005, this court is of the view that no blanket interim order can be passed. Full stop. It is accordingly submitted, it is accordingly provided that while the petitioner would be at liberty to submit his candidature in the present recruitment process via the advertisement dated 29/5/2025, the same would be without prejudice to his rights espoused in WPC 5045 of 2024. It is also provided that no final decision be taken in the new recruitment process without taking leave of this court. Hopefully you will be selected. Then you will withdraw both the petitions.
Other the
29 number.
other the instruction received by me, a copy you have.
Which one?
The instruction received by him.
No, those are his copies. Only the documents. And you have you filed your affidavit?
Yes. In the other case, but I have filed in this case also.
Okay. In the other case, you write?
There is nothing internal mile because the select list and the mark
List
mark
along
are
with
to enter.
5045 notice
Not collect my
list along with WPC 3018 of 2025.
All right.